I think we're live now. Yeah. Okay. All right. So we can start the session. So good evening to everyone who's tuned in. Today's session discusses the important theme of the enduring colonial legacy, the new criminal laws. We are joined today by our two eminent speakers. Allow me to introduce you to them. Naveed Mehmood Ahmad. He is Senior Resident Fellow and Team Lead Criminal Justice with the Center for Legal Policy. And Ayushi Sharma is Research Fellow Criminal Justice with the Center for Legal Policy. A very, very warm welcome to you both.
Thank you, Tia.
Thank
Thank you.
you for having us.
So, to begin with, you discuss in your article by stating that while the decolonization process has come to the fore politically in recent years, however, the three new criminal laws are not a straightforward outcome of the exit of the colonial forces. And though a reform in the Indian system has been long overdue and it is generally seen as a welcome change, what, according to you, are some of the basic problems with these three laws? Further, do you think that India could have borrowed some of the takeaways from the varying decolonization processes across the world?
Uh, I am not aware if there are any concerted decolonization efforts in terms of the law, in terms of the criminal justice system across the world. But it has been a very important academic topic. And in terms of moving from colonial to post colonial systems, it is very important to really achieve decolonization in the truest of sense. And when we look at systems that are created during the colonial period, whether it is whether it is law, whether it is processes, whether it's the systems, governance systems, policing, and all sorts of things, they are created in a particular context, and that context may not always be bad. They may not always be, and these in these processes, these laws and these systems may not always necessarily be bad. But because they are created in a specific context, post-colonial governments must do a deep dive into these systems, into these laws, into these processes to really see whether they fit into the modern ideas, with the modern, and are in sync with the democratic values of a post-colonial state. And that is true for India, that is true for any other post-colonial state. And when we say that decolonization is not a direct outcome of the exit of colonial forces, it is true. 15th August 1947 did not change our systems remarkably. It did mark a change in the political power that was governing India. It did change India from a colony to an independent sovereign state. But the systems that were in force, the law that was in force was from the colonial periods. And I would like to repeat myself again that it may not necessarily be bad. And that is true for a lot of criminal law, which continues to be acceptable across the board, even in pre-colonial, post-colonial systems. Murder would be a crime anywhere in the world. Theft would be a crime anywhere in the world. Dacoity is a crime anywhere in the world. So it's not necessarily bad. But as I said, there are imprints that this colonial rule will have on the governance mechanism, on laws, on processes. And it is very important for post-colonial governments to look into it. And it's a gradual process. It's a process that should have started in 47, that should have continued till today. So my concern with the present laws is not necessarily something that is bad within them. It is the fact that they promise that we are decolonizing, but very little is being done in furtherance. What they do is they very fantastically clarify the problem statement of India's criminal justice system. India's criminal justice system is still deeply rooted in colonial ideas. It needs decolonization. India's criminal justice system is not citizen-centric. It needs to be made citizen-centric. India's criminal justice system is still rooted in punishment. It needs to be rooted in justice. And all of these things are very important to any decolonization exercise. So the goal, the vision that these laws set is absolutely correct. what they do in furtherance of this is somewhere that we really need to engage with them and figure out what is the best way to ensure that these objects of the law are fulfilled, which in our view they're not able to do at this stage.
Yeah. Thank you for explaining the context to us. And you mentioned in your article that when we unravel colonial history, we realize how intertwined it is to other systems apart from the law. It's also to do with how the police apparatus was set up, how the justice system was set up, and these two are very interlinked processes that we have to unravel in a post colonial setup.
Yes, that's what I said. The colonial government, this is institutions or tools like the criminal law are very important tools. They're very powerful tools.
Yes.
And for say something like for a colonial power entering into India for economic or political reasons, criminal law and criminal law machinery becomes a very important tool because it has the power to deny an individual its life. It has the power to deny an individual its liberty. Criminal law can tell the citizenry what they are allowed to do, what they are not supposed to do. It can impose punishments for them, and this police person is perhaps the most strongest and the most visible arm of the government on ground. And so there was no way that the colonial government would not use an instrument like this. So when we say that criminal law per se was when we say that Indian criminal law and the criminal justice system operated or was envisaged in a context, the colonial context. It's very important to see how the colonial administration at that time used these laws and used these processes to further their interests, to further their economic interests, their political interests, and it was not merely a crime issue. It was not merely a criminal handling of criminal law issue. It was also central to their administering a colonial territory. So we need to really understand how the criminal justice system of this country was useful to them and how they used the apparatus. And while the context will change, the context certainly will change post independence. The state may not necessarily want to use that same machinery in the same way that a colonial state was using. We did not have a robust fundamental rights mechanism pre-independence. There was no, I mean, life and liberty was not cherished as much as it was post-independence. Our fundamental rights of free speech, assembly were not as cherished as they were. I mean, they were not in existence as they were post-independence. So the whole context changed. The way that the state was now supposed to look at criminal law, its object, how they were supposed to look at police, their role in the society, how the state was supposed to look at prisons and their role in the society changed. So it's very important for any post-colonial state to do a deep dive, as I said as part of the previous question also, and see with the change in context, the relationship between the state and the citizen changed considerably. The citizen was no longer a subject of this colonial administration. The criminal law was not no longer a tool to further economic and political goals of a foreign government. There was a need to reimagine the role of criminal law post independence, which I think did not happen starting off in 47 and the years after.
Hmm. And you also mentioned the irony that under the mask of change and change that is very fundamental, we're actually retaining a lot of these systems of control at the end of the day.
Yes, absolutely. And there are a lot of these systems in terms of even substantive law, how we define crime, the extent of criminal law in this country, general activities, how we criminalize free speech, how we criminalize assembly, how we criminalize, how we use punishments, how our system is still rooted in ideas of deterrence and retribution, how we over rely on imprisonment as the only form of punishment. All of these things are remnants of the colonial past. And moreover, you see the extent of power that the police has in terms of power to arrest and on merely on suspicion. The amount of preventive detention law that we have in this country, and there are at least 25 state statutes around. So there's practically everything one can be preventively detained for any offense under the IPC. So there's practically no need to go under the IPC and adopt the regular course of justice. So all of these are remnants from the colonial past. Preventive detention law, policing powers, the extent of crime in India, criminalization in India, the form of punishments. We have virtually not seen any change in the past 70 years. And I'm afraid these laws also don't do anything concrete in that direction.
Right. Could you also elaborate on how crime and criminality was fundamental to the British colonial rule compared to an independent and democratic state's requirement for the establishment of criminal laws?
No, as I said, a government, a state, wanting to ensure public order, only for the purposes of ensuring public order, has a different view of crime and criminality. They want to ensure public order. They want to ensure law and order. They want to ensure that national security of the state is protected. But when you place the same thing in a colonial context, that is not it. Criminal law becomes a tool that is able to achieve far more for the colonial state than it would for a than it would ordinarily, because ordinarily criminal law is supposed to define crime for you, tell the citizens that this is something that you're not supposed to do, and provide a punishment for it. And the procedural law will provide all the procedure and the mechanism that could ensure that this person gets justice. But in a colonial context, that is not it. uh, the policing apparatus was envisioned and from a not very not from a view that we need to control the people of India. We need to control there is no mechanism in place in India. There is no criminal justice system in India, and we need to tell the Indian masses how it's done. It was also used to ensure that local rebellions were taken care of. There were some militaristic ideas that were still rooted in the policing system that the colonial government envisaged in India. And even investigative agencies, your CIDs, all of these were visualized in more in terms of keeping an eye on the national movement. And when you have systems, when you have let's say institutions like the police germinate in a context like these, they will continue and continuing in a context like this without having reimagining their role in a society. They'll continue to have these problematic underpinnings. It's always going to show in multiple ways, even in a post-colonial situation.
Absolutely.
Yeah. So coming back to what you said in terms of crime and criminality, it is not so much in terms of well, there is of course a role for a police. Of course, there is a role for the criminal law to play. And as I said, the IPC, a lot of the IPC is still continues to be the 1860 IPC continues to be in use today. Even the Bharatiya Nyaya Sanhita continues to derive 90% of it continues to derive from the IPC. So there is always going to be an acceptance. There's always going to be a general acceptance of the fundamental crimes that the world sees. But it is that bit, uh, for example, excessive police powers. We need to see that in a particular context. We need to see that in a context of why the colonial government wanted the police to have such excessive powers. Why was the police vested with the powers to detain preventively? Why was the police vested with the power to detain on mere suspicion? These are all cases, these are all situations that were used to quell dissent during colonial times. These were all powers that were used to ensure that leaders of the national movement were put into prison for carrying on the movement. So that is fundamentally what is colonial with our system. Lack of any, just one last point, lack of any rehabilitative idea in our whole criminal justice system. What is the role of our prisons? If you go back a few into the history of prisons in India, if you go back into the history of punishment in India, you would visualize how you'd see how it was reform and rehabilitation was never really considered, and that stands true even today. So absence of all of those ideas are core, are critical to the coloniality in our criminal justice system, and that continues today.
Absolutely. And without that sort of empathetic lens, I don't think we can ever fully reform any criminal justice system. Very interesting points. I mean, each of your questions, I think, requires a separate session of its own. But coming to Ayushi, um, how did colonial lawmakers' perceptions of the native Indian population influence their lawmaking? Could you share examples of the colonial era laws and practices that have till date continued to impact India?
So I think colonial lawmakers' perception of the native Indian population significantly impacted the criminal lawmaking, the kinds of offences that were created, the kinds of punishments that were imposed. Now these operated majorly at two levels. First was the fact that the colonists believes that the indigenous people, the savages lacking a proper legal system,
Hmm.
that led to them imposing on us European legal structures and dismantling the traditional legal structures that we had. And second was the racial biases and the religious differences. Colonial powers didn't really understand indigenous religions, castes, tribes, right? So this often led to them criminalizing people, displacing them, so that it was easier for them to control them. I use two examples. The first is the suppression of Thuggy Act. Now, thuggy as an offense is basically robbery when carried out with murder by a group of individuals. Now, this as an offense was rampant during the colonial period. Now, this as an offense is a substantive offense which needs a separate attention, and while the offense was generally motivated by economic deprivation, the colonial administration linked it to religious practices, cultish practices.
Yeah.
It was thought that certain tribes that praise certain deities commit dacoity,
Hmm.
commit thuggy, right? Now, the spearheader of this campaign, William H. Sleeman, in order to understand how this offense is committed, started profiling people, started detaining them, started maintaining their account, details of all these thugs. So this gave it a very cultish color. It gave it a very religious angle, which was not required, right? Now, this improper framing of the problem led to adoption of extraordinary policing practices, surveillance, and this continued for a very long time. Another example of such a law is the Criminal Tribes Act of 1871. Now, the law was inherently based on the belief that there are certain tribes, there are certain castes that are inherently criminal. If you're born into a specific tribe, or if you perform a particular kind of an occupation, or if you're a particular kind of a nature, you are a criminal. So now these criminal tribes were nomadic and semi-nomadic communities which used to move around the country. They didn't have mainstream occupations like agriculture. So their lifestyle basically made it difficult for the colonizers to regulate them, to control them, to tax them. So they criminalized them. Now, this particular act, it unleashed a reign of terror. I mean, you had provisions like if a child is born into a criminal tribe, they could take away the child. There were detention camps. Criminal people belonging to criminal tribes were put into forced labor. Now, even though the act was repealed and we no more have criminal tribes, now the notified tribes are now called denotified tribes, they still continue to be ostracized. They still face harassment at the hands of police. So the impact can be seen even today. So this is how the racial bias, the perception of native Indians shaped criminal lawmaking during the colonial period.
You also mentioned that there's a specific doctrine, we can call this trend as, which is the guilty by association doctrine. Could you elaborate on that?
Yes, so this is in specific reference to the suppression of Thuggy Act. So, um, generally under criminal law, you have to prove intention to prove a crime, that the act was committed and there was sufficient mens rea to commit that act. But
Okay.
in order to ensure convictions for Thuggy of native Indians, they introduce special evidentiary standards in the courts so as to ensure that all the thugs are convicted. So even if you're associated with a group of people that could be termed as that has some connections with some dacoit, you could be put into prison, and that is how this doctrine of guilt by association was used in this context.
Okay, understood. Um, you also mentioned that the renewed criminal laws fall short on several fronts. What are some of the core problems with the colonial idea of reformation? and prison as the site for reform?
So there are two parts to it. I think first is the substantive bit where what offenses have been incorporated, and second is the punishment part. How there's a lack of focus on reformation, and can prisons really be seen as a site of for reform? So, during the pre-colonial period and the early colonial period, the criminal justice system was mainly governed by religious laws. So, in terms of punishments, you had very harsh and very harsh punishments like maiming, disfigurement, stoning, beheading, right? So,
Right.
in the 1860s, when the IPC came, the punishment, the discretionary part of the punishment was concretized, and you had five to six forms of punishment that were listed in Section 53 of the IPC.
Okay.
You imprisonment, transportation, fine, forfeiture, and punishments of these imprisonment for life.
Hmm.
Now, even in these punishments, the idea was never reformation. It was always isolation. So, let's take for example the punishment was specifically included in the IPC because transportation, which meant you act physically a separate colony to serve the sentence that was outside India, related with the idea that it will terror amongst the citizens because travel beyond the seas had certain superstitions attached with it. For seen, it was considered to be much more worse than staying in prison. So transport for the native Indians. Imprisonment within and short-term sentences was considered to be fit because it would deter the criminal. It would incapacitate the criminal from committing further offenses. So I think reformation was never the goal. Even prisons as a site served to harass Indian natives criminals. It was not seen as a sign as a site for reformation ever. Although CRP provisions, you had provisions like admonition, probation, which could then divert the convict from going into the prison to a separate system used. We still have the
Okay.
Probation of Offenders Act. We still have these provisions in the CRPC, but very used ever.
So, what other remnants of this system of fear, punishment, and terror do you observe in the present administration?
I think offences that were there in the law, we have the offences that were designed in 1860 back then in the IPC were designed to consent. They were designed to control the citizen. They were designed to regulate them. You had offenses like sedition. You had offenses like criminal defamation, which were the objective. In terms of punishments, we continue to have all the punishments that were there in the except for transportation, which was um, imprisonment instead of transportation. And now community service has been added as a separate offense, separate punishment. Now community service is a welcome step, of course, but of the punishment is so limited that out of let's say over 400 offenses, community service is only applicable to six offenses. That are also very petty offenses. The idea of punishment has not changed, has not evolved. We still continue to, uh, if I may say so, rule the people by with fear and terror. We want to control people and regulate them.
Absolutely, and I think it begins by simply stepping into a police station. Um, for those of us who've been. Coming back to Naveed, uh, are changes in the laws enough? You discussed the gradual building of a police state in colonial India and how the police And I quote, the police in India never really severed ties with its ideological and militaristic leanings. Thus, bringing a shift in the institutionalized oppressive nature of the police remains a formidable task.
It does. I started off by saying that police is the most visible arm of the government. It is perhaps also the most powerful arm of the government on ground. And when you see a police constable on the road is or an SHO in a small town in village is a very powerful person, and why they are powerful is because they are because of the institution of policing. They are powerful because of the powers that the Criminal Procedure Act vests in them. They are powerful because of the powers that the preventive detention laws vest in them. And unless we change the way we look at policing citizens, very little can be expected out of any amendment in the law.
Hmm.
And when I say that, I would urge, I'd go back to what I said earlier. The nature of relationship between the state and the citizen changed considerably post independence. The post colonial state wants to protect a citizen's fundamental freedoms, freedom to speak, freedom of assembly. The post colonial state wants to protect the citizen's right to life and personal liberty. The criminal law, our policing practices, the powers that are vested in the police needs to now be brought in sync with these expectations, with these constitutional obligations that we have. And but we have over the past many decades failed to do anything in this direction. So any decolonization effort must start, like Ayushi just pointed out, must start from imagining what crime should mean in a modern day India, what crime should mean in a 21st century India. It certainly can't mean the same thing as it meant in 1860, right? We've come a long way today, and so it should also mean what punishment means for a for a modern country like India. And maybe imprisonment is required for a lot of these offenses. Maybe it's not for many offenses. Maybe community service should not be restricted to these 4 or 5 offenses that it is under the Bharatiya Nyaya Samiti. Maybe it can be extended to many more. But in addition to that, the way the police as an institution is envisioned, the way the police as an institution is utilized by the government, by the executive,
Hmm.
that remains very crucial. Because as long as that does not change, any amendment in the law will not have any effect. Now, I'll tell you how. If you see, a lot of these provisions that Ayushi mentioned are very vaguely drafted.
Yes.
Provisions of sedition now replaced by a similar provision on offenses related to sovereignty and territorial integrity, provisions related to criminal defamation. There is another provision in the law called which basically criminalizes misleading news. Now, who really decides what is misleading? Who really
Exactly.
decides what is a threat to national security? It is There is enough power with the police to arrest a person on mere suspicion on any under any of these provisions, and that's not the problem. The problem is that this power to arrest is used so frequently, or rather misused so frequently, that if you see today, the NCRB data will tell you that, and if I remember, it was 2021. Your 89 lakh people were preventively arrested under the Criminal Procedure Code. The people arrested under substantive law for offenses that were actually committed was hardly above 50 lakh. So you had far more number of people arrested on suspicion preventively in a case where no offense was committed. And only 50 to 60 lakh people were arrested for actual offenses that were committed. So you see the extent of power that is vested in the police. It may be necessary in some situations, but it is important that at least at this stage we draw a line as to
Yeah.
where does this stop.
Absolutely. And on the other end of the spectrum, we also see that within these laws, not only there are vaguely defined terms, but also very narrow safeguards for the citizen to approach the system if they have been wrongly um, accused of uh, something.
Yes. Yeah, and that remains, that's a hallmark of the coloniality in the system. That is the fundamental reason why we keep going back to the question about decolonization. The system was never really looked from a citizen looked at, I mean, the state never really looked at the system from a citizen's perspective. It was always the state's perspective. As I said in the beginning, criminal law was always a tool for the state. It was a tool for the state to achieve their economic and political goals. It was used in a way that ensures that the colonial that the expect for the colonial expectations were fulfilled, and the policing machinery, the judicial machinery, the legal setup, the way the law was written was a lot of it was in that direction. and
Absolutely.
and that's never really changed. Would you please repeat the second bit of your question? I lost the thought there.
The second bit of the question I'd asked initially.
Yes, yes, yes.
Okay. Um, you discussed the gradual building of a police state in colonial India and how, I quote, the police in India never really
No, the
severed.
second, the after. Okay, nonetheless, that's fine. So what I was saying is that it's important that you need to envisage a system. One more example in terms of the abuse of powers. In terms of the abuse of powers, from a citizen centric perspective. That's, I think that's what I was missing. From a citizen centric perspective, when the state was looking at criminal law for to achieve its own objects, to achieve its own goals, economic or political. It was never really concerned about how the citizen is supposed to navigate the machinery. Let's say at a police station, at in the court system, in the prisons. What is it that the punishment is supposed to achieve for the citizen was never really part of any discussion. Was never really thought of when we were drafting our IPC. Was never really thought of when we were drafting our Evidence Act or the CRPC. But today, when we want to move towards a more citizen centric system, we need to ask ourselves this question as to how are we looking at this citizen? How is the police interacting with these citizens? But when you look at data, for example, you can get, like I said, in the preventive detention data, data on preventive detention or preventive arrests. You don't really need to commit an offense to be in prison for long. And there is very little incentive for the police to fast track their investigation, to file their charge sheets and seek a conviction when there is enough law to keep a person in detention under trial, or to keep a person in preventive custody for years and years, because nobody really is looking for a conviction. And we have all of our these special laws with these provisions on bail, very rarely people getting bail, of course, and concerns with excessive use of preventive detention and preventive powers. It is by no stretch of imagination a system where a citizen can actually navigate its way through, because there's nothing that was envisaged for that. There was nothing that was envisaged for the citizen to use in terms of legal tools. So a system where process is the punishment in itself, where there is no incentive where there is no need to secure a conviction, misuse will always happen.
Okay. I think tying to this point of yours,
Yeah.
we've also seen how countless instances of this colonial hangover continues to affect the access to justice, especially to vulnerable groups in India. So, could you please explain this with certain instances and trends that continue to exist?
Uh, Taking from what Ayushi had mentioned, the biases and prejudices that the system gave rise to back during the colonial times, it is very visible even today. The nature may have changed, but it continues to operate in very complicated ways for a lot of communities in India. And there is enough research that documents how policing in India is biased, how the system operates in a prejudicial way for different communities. But one way of understanding this is looking at data on in prisons. And if you look at number of under trials, constantly over 30% of India's under trials belong to the SC and ST communities. And in many states, it's far beyond their proportion in the population. Similarly, if you look at preventive detainees, and I keep coming back to this, 35% of preventive detainees in Indian prisons are Muslims. Their population share is only 14%. When you look at this, their 35% when they are around about 35% when they are of preventive detainees are Muslims. It goes down to around 20-25% for in cases of under trials. So 20-25% of under trials would be Muslims, which is again going to be at least around about a double of their population percentage. But their conviction, the number of convicts in prisons, the number of the percentage of Muslim convicts in prisons is almost around their population, proportionate in proportion in the country. So you say with an added layer of scrutiny by law, with an added layer of scrutiny by the judicial system, you see the number of convicts is almost in proportion with their population share, with their share in the population. But the number of preventive detainees, where you are subverting judicial processes, where you don't need to present them before courts, where you don't need to, I mean, where you're not bound by an ordinary criminal procedure or evidentiary standards and all of that, you have a 35%. You see the extent of overrepresentation in terms of preventive detainees. So this is, I don't see how different this is from a colonial period where you will have certain tribes being targeted. So the system has operated in a biased way for many communities, and it continues to do so.
Hmm. Yeah, and this ties in with Ayushi's earlier point, which said that they didn't know what to do with them, so they criminalized them. It's as vague as that.
No, but
Uh,
there is also enough to use it for other goals today. There is enough provision in the law, be it substantive law or be it procedural law. There is enough provision to use criminal law for any gains, for any objective. It could be political objectives. There is enough tools to use special laws to achieve objectives that are far beyond the object of the law. In essence, what the law was made for, or what the law was envisioned as.
Absolutely. So there's also a need to not just reform the law, but also to reform how we use that law. Uh, Coming to my next question, what are some of the specific provisions of the Bharatiya Nyaya Sanhita that continue to retain some of these biases, and how can we overcome these to make the laws, as you said, more citizen centric?
Yeah, so maybe I can take the first part of the question. So, both in Bharatiya Nyaya Sanhita and the Bharatiya Nagrik Suraksha Sanhita, not much has changed. It's the same law that we used. We continue to criminalize the same thing in the same manner, or rather harsher punishment for some offences. So, under the BNS, we continue to have same vague and arbitrary offences. Defamation continues to be a crime. Promoting enmity between different groups continues to be a crime. Outraging religious feelings, under which every day an FIR is filed, continues to be a crime. Now, these provisions have a history of being misused, and all of us are aware of it. We read, there are too many news articles on a daily basis. So,
Yes.
all of these provisions have been retained. Now, there were certain provisions which were incorporated in the IPC, keeping in mind the Victorian moralities of that time, right? But we still have those, we haven't changed them. So, marital rape exception continues to exist.
Right.
Even though we have had judgments where we have recognized sexual autonomy, agency of women, even married women, it's still treated as an exception. Um, while even though adultery has been decriminalized, we have a provision on enticing a married woman. Now, the provision then was based on the belief that women don't have agency; they are docile. There's this
Perception.
the perception that there's no agency, but we still have this provision. We continue to criminalize abortion. There are slew of provisions under the BNS that criminalize abortion. We also have these obscenity related provisions. Now, we don't really know what obscenity means because there's no definition. There are certain tests that have been developed by the courts through in the last few years, but It's again very arbitrary and based on the Victorian morals that existed back then. The whole idea of obscenity comes from there.
Yeah.
There are certain new offenses that have been introduced, offenses like organized crime, terrorist activities, fake news, publishing misleading news,
Yes.
petty organized crimes. Again, all these four, also a different variant of sedition we have, acts endangering sovereignty and integrity of India. All these provisions have such vague phrases that you can arrest anybody and everybody under it. There are no proper definitions. And for offenses like organized crime, you have very harsh punishments. You have life imprisonment, death penalty.
Yes.
Under the BNSS, again, not much has changed, although the powers of police have been expanded a bit. Provisions for preventive action by police have not been changed. Asking for security, for keeping good behavior, all of these provisions have been retained. You have another additional clause which states that, which gives the police the power to detain any person resisting or refusing to follow directions passed by a police officer. Now, this direction can be any direction, and the refusal could be because of any reason, but it still gives the power to the police to arrest. Section 144 of the CRPC, which gave uh, a magistrate the power to issue urgent orders. Now, this provision has been retained as it is. We have seen that this provision is used very frequently. And back then, the provision was designed to regulate mob, to control public agitation, to regulate public gatherings and assemblies. But now it is used for this reason as well, but it is also used for various non urgent reasons. Another problematic provision under the BNSS is the power of handcuffing that has been given to the police. The provision lists out certain grave offences where the police is allowed to use handcuffs. We have had decisions where the court has held that using handcuffs goes against the human rights of any person,
Right.
but we have that provision. Another just last point. One more provision that has been retained is uh, that has been changed is the power of police custody. So initial essay under the CRPC under section 167, a magistrate could extend the initial period of police custody up to 15 days. But now this period has been altered, and this period of police custody can be extended, can be claimed anytime by the police within the period of 40 days or 16 days, 60 days, depending upon the offense that has been committed. Now, this raises serious concerns about. This gives first it gives a lot of discretion to the police, and it raises serious concerns about misuse because police remand as it is a problem and abuse generally.
Right.
So yeah.
Absolutely. We also have an audience question which ties into my question only. But which is, what do the speakers recommend be the solution to changing the colonial legacy of our legal system and the laws?
Yeah, so I'll take this one. As I said, these three laws set a very good problem statement for us, and the acknowledgement that the system is still colonial, the acknowledgement that the system lacks citizen-centric processes, the acknowledgement that the system still prefers punishment over justice, and that the system is, of course, in dire need for speedier disposal of cases, is very important. It frames the issue very well for us. And as Ayushi has pointed out, with the various provisions in the law, we can clearly see that there is a need for reform in both the substantive criminal law as well as the procedural criminal law. But where do we start this? This needs, and this is, I think, at the cost of repetition, I'll say it, this needs to start. The change needs to start from the way the way we imagine crime, the way we define crime, and the extent of criminal law in this country, and the amount of criminal law that we used to solve social and regulatory issues is massive. we use imprisonments to solve uh, uh, issues that have very little to do with issues of public order, national security, or or territorial integrity of the country, or law and order. We use criminal law to solve issues such as failure to register live-in relationships under the new Uttarakhand Uniform Civil Code. One really needs to ask the question as to what is the expectation from criminal law by the state. So I think that has to be the starting point, where we have to reimagine the way we conceptualize crime.
Right.
Once we do that, we limit the scope of criminal law.
Hmm.
We do not allow criminal law to be used for political purposes or for any other purposes. And that really can take us to our second question on reimagining punishments. Because the way we used to punish 150 years ago cannot continue to be the way we punish today. Surely the nature of a society has changed. The nature of our polity has changed. From a colonial system, we are a modern democracy in the 21st century. We cannot continue to punish people the same way we did 150 years ago. So that takes us to the step two, which is reimagining the way we punish. Of course, bringing in community service is a great step. But why do we restrict it to four offenses? Why is it to not exclude jail terms? Because still the law says you can either be sent to jail or community service. Why can't there be a provision only for community service? Why can't we start using our probation of offenders act? Because virtually all offenders can actually go for probation under the probation of offenders, but it's a seriously underused law.
Right.
And all of these more conceptual changes, the issue of what is crime and how do we punish, then needs to be accompanied by better criminal law drafting. We need to draft criminal laws in a way where we are able to tell the citizen of this country what act of theirs is criminalized. I can't be caught. I mean, there can't be a situation where I'm caught by surprise by something that I have done, which amounts to a crime under some kind of a reading of a provision. So if I if I don't walk my dog, if I don't give reasonable exercise to my dog, that has a potential to amount to animal cruelty under the Prevention of Cruelty to Animals Act, and we can go to jail for that. Now, the goal of the law is very important. We need to ensure that there is no cruelty is meant. No animal is dealt with cruelly, and all of those things. But do we not feel the need to write the provisions in a better manner so that it's clear? Similarly, the act of misleading information under the Nyaya Sanhita, who decides what misleading information is? For someone, an information could be misleading. For someone, that information may not be misleading. But how do we criminalize something as vague as that? How do we criminalize defamation when there is a civil procedure in place, when there is a civil adjudicatory mechanism in place? What is the need to use a criminal defamation provision? So once we reimagine the way we look at crime, once we reimagine the way we look at punishment, we also need to look at how we draft our provisions so that they're clear, they're precise, and they tell each and every citizen what is the act that is prohibited and what is the act that they can land up in jail for. Then
Absolutely.
all of this needs to be accompanied by systemic changes in the way that the police operates, the police interacts with citizens, the provisions are used. Certainly their powers of preventive arrest need to be curtailed. Our reliance on preventive detention laws need to be curtailed. There is an overwhelming amount of preventive detention law in this country, which should not exist in a post-colonial state.
Absolutely. I think that neatly sums it up that we can all agree that unless we build consensus on what even encompasses decolonization, or or we clearly define the terminologies that are there in our present criminal laws, we can never truly hope for holistic justice. Thank you very much to both of our speakers for joining us and giving us so many invaluable insights. For those who wish to read further, their article is very much available on our EPW website. Please go check it out. As a side note, I'd also request you to please support EPW, subscribe to us, follow us on our social media. And thank you very much once again to both our speakers.
It was our pleasure to be here. Thank you.
Thank you.